So it is essential that one creates that impression, that reputation, that he is going to be fair in what he's arguing.
Welcome to the Bombay Bar Association Podcast. Today, we and I have the fortune of interviewing a towering personality in the field of tax law, Mr. Soli Dastur. Mr. Dastur is one of the few tax counsels who has established a global name both within India and also outside India. So Soli, thank you for being here, and let's begin with the early years.
First of all, Porus, thank you for giving me the questions you were going to ask as I was entering this building. It reminded me of my Bar Council examination days. If the paper was from, say, 11 to 2, we were asked to be present by 10:45, and at 10:50 the questions were given to us. We had 10 minutes to peruse them before we started answering at 11. And therefore, obtaining your questions in advance reminded me of that occasion.
You joined the chambers of RJ Colola, a very respected tax counsel. What were your early years like with Mr. Colola?
Now, you asked me what were my early days. You stated correctly that Mr. Colola was a tax counsel of repute. Let me add that this was in his later life. Earlier, he was very active in civil law practice and was a leader in civil law. Later, he started specializing particularly in tax and labor laws. You referred to my joining his chamber. I qualified and was enrolled as an advocate on 7th August 1959. It is a date which stands out in my memory, and that it was on 7th August became somewhat sentimental. I say this because on 7th August 1937, when I was about 2 years old, I fell down from the balcony of our building at Colaba onto the road, and some say fell into the gutter. I'm not quite sure of that. The lady who was holding me was scared and immediately left the flat. A British soldier who was walking by picked up this body and went from flat to flat to inquire to whom it belonged. When he came to our second floor, my mother, who was not aware of the situation, was shocked. The soldier told her to come immediately and not change her dress as she wanted to, because he wanted to take her and me to the St. George's Hospital. That hospital at that time only looked after people of white origin. Because it was a British soldier who took me, they admitted me into the hospital. That is why I say 7th August, the day on which I was enrolled by passing the examination for the office of an advocate in the High Court, stands out because it always reminds me of another 7th August. You asked me, how were my early years of practice? If I may answer with one word, they were briefless. I say briefless because in my first year of practice, 59-60, I earned rupees 30. And that was also by chance. A brief was carried by a person to be delivered to an advocate to appear in an adjournment matter fixed after the lunch break. he could not find the advocate. Fortunately for me, he saw me walking around and gave the brief to me. That is how I earned my first rupees 30. Even 3 years later, I don't think I earned more than 3,000 rupees in the whole year. You will now appreciate why I say the first years were briefless. But they were not useless. I learnt a lot. Mr. Kola, who was given a brief for, say, a conference or advising in conference or appearing in court, would hand over the brief to one of his juniors. At the time when I joined the chamber, his two juniors were Mr. Dilip Dwarkadas and Mr. Ramaswamy. Mr. Dilip Dwarkadas primarily engaged in income tax practice, Mr. Ramaswamy in labor law practice. Mr. Kola would hand over a brief he had received to one of his juniors, who was responsible for preparing a note for his consideration. He would go through the note and he would ask the junior who had prepared it to attend the conference with the instructing chartered accountant or solicitor. And it was for the junior in the conference to prove his mettle so that the instructing solicitor or chartered accountant felt that this was a chap who may deserve another brief. Mr. Kola never recommended a particular junior to be briefed in the matter because he felt this would mean that the other junior may not get the brief which he would otherwise get. So this is how, in the early years, I learned how to practice, what to do. And I remember to work on the papers Mr. Kola had given us, we used to sit in the High Court library. And I often walked out of the library at about 7:30 p.m. when the library shut for the day.
Just going back to what you said, what we used to remember is that you probably didn't earn 30 rupees. You earned 2 gold mohors.
Yes. Yes, I'm glad you refer to this. The brief was marked with 2 GMs, and in Bombay, 1 GM was equivalent to 15 rupees.
And that was a peculiar system which remained even
today. I mark in GMs, normally people don't. But what is surprising is that in Delhi and Calcutta, the GM was valued at 16 rupees or 17 rupees.
And no one knows why.
And therefore, perhaps the advocate practicing in Delhi with a 2 GM brief may earn 34. In Bombay, he would earn 30. Since you referred to this, let me also point out, as I recollect, I was so thrilled with the brief delivered that I took my very good friend at that time, Mr. Piyush Amin, to the Regal Cinema to watch a movie. The ticket at that time, normally, not for the balcony but for the ground floor, was 1 rupee and 5 annas, which is about 1 rupee and 33 paise. We bought 2 tickets, had ice cream in the interval, with the result at the end of the day, I felt that out of my 30 rupees, I probably had only 15 rupees left with me.
Thank you. Before becoming a counsel, you also met Mr. Nani Palkhiwala, who you wanted to work as a junior, but he declined. Later you said you were lucky that he did not take you on. Why?
Yeah, because, say, 2 or 3 years after I started my practice, say in 62, 63, Mr. Palkhiwala started devoting more and more time to the House of Tatas. Later, he was allotted a chamber in Bombay House itself. And he would visit that chamber and come to his chamber number 3 only in the evening around 7 p.m. with the result that his juniors did not have that interaction with him as you would have had with a lawyer who was practicing in his high court chambers all the time.
But Mr. Palkhiwala also offered you a well-paid job at Tata's at a very early stage in your career.
Yes, you're right. I discussed first this matter with my father and my brother, who were leading chartered accountants in the profession. They both said, you should not take it. I discussed the matter with juniors in chamber number 2 and chamber number 3, in which your father, my good friend Farouk, also participated. All of them said, you should not accept it because it will affect your independence. And I did not accept, and I have no regrets, obviously. It taught me one more lesson, that there are temptations in life which one must resist. And if you don't resist them at the relevant time, you may regret it later.
And I think that's true for most counsel practice, that the struggle, because many go into firms or companies today, that the struggle of the initial years is worth it in the long run.
Absolutely, absolutely. It is worth it. It teaches you a lot. And what is more, it makes your reaction with other juniors pleasant and more constructive, because you recollect the problems you face and you wish the juniors don't face those problems.
And also what you said is critically important, is that we are able to keep our independence throughout our lives without becoming a part of any institution or anything else. And I think that value is unique and special in its own way.
Absolutely right. In fact, Mr. Kola was many times offered directorships of company, but he steadfastly refused because he felt it would affect his independence and how he looked at a problem. Supposing the company in which he was offered a directorship had a particular issue, and it was decided by the directors to tackle it in a particular manner. If a company who had a similar issue approached him for his advice, he would find it difficult, though he felt it was better to do something other than what the directors had decided. He would find it difficult to advise them, because he cannot, as a director, advise his company to do A, which may be because of certain reasons, and advise a company which approaches him, which doesn't have the same identical problems, in a different manner. And therefore, he never accepted a directorship.
At what point did you get the impression that your luck at the bar was changing for the better?
I would say about 65 or 66, when I was 7 years in practice, when I felt that, yes, I was getting work and that I was enjoying, what is important, I was enjoying the work and learning a lot from it.
One of my fondest memories or recollections in the chamber was on a Saturday afternoon when we were both briefed in a matter in Hyderabad. And we were not sure whether the matter which was supposed to come up on Monday is likely to go on or not go on. And I could see your hesitation in not wanting to go there and the matter getting adjourned. And the clients also seeing your hesitation said, and I think they meant it in a sort of comforting way, that, sir, do not worry, we will anyway be paying your fees. And I remember your statement when you said that fees can be earned anyway, but time wasted can never be got back. Where did this philosophy and approach come from?
I think from my father and brother, who also felt that you can always earn more money by doing more work. But you never have more time in life The time you have in life is fixed. That cannot be increased. The amount of money which you earn, you can increase. And also, that time well spent perhaps gives you greater satisfaction than more money earned. Because after a time, money really doesn't further happiness as such.
Now, shifting to your own expertise area and on the evolution of tax law in India. In 60 years now of your legal practice, what are the key ways that you have seen tax law evolve in India?
To put it in one word, tax law has evolved at a fantastic pace, and the evolution can be looked at from various points of view. For example, evolution of tax law can be looked at from the point of view of the enactments with which you are concerned. When I joined the bar in 1959, I think the main direct tax acts were the Indian Income Tax Act 1922, the Estate Duty Act 1953, the Wealth Tax Act 1957, and the Gift Tax Act in 1958. Today, all of these have been repealed. And it is with the Income Tax Act 61, which came into force on 1st April 62. You may call it the April Fool's Day Act, and which has now been in force since 62 to the present day.
If you were given a chance to advise the judiciary and also lawmakers on how to create a balanced tax system that caters both to the government's needs and also taxpayers' rights, what would that be?
Let me just say this first. The Income Tax Act had and has various provisions for appeals. You can appeal to the Commissioner, to the Tribunal, if necessary to the High Court and the Supreme Court. But it has two other remedies. One is a body called Advanced Ruling Authority and an association whereunder you can apply for settlement of your case. So I think these two bodies, settlement and advanced ruling, the lawmaker should encourage people to take matters up there, because that will save considerable time spent in fruitless litigation. Now, to induce people to go there, because people don't patronize, is because the constitution of these committees is such that they don't have confidence in it. They look on them as revenue biased. Therefore, as a lawmaker, they should ensure that these committees have representatives from the government, from professionals, and from assessees bodies, so that they inspire greater confidence.
You also argued as amicus in the Mahindra Mills judgment on depreciation.
Yeah.
Do you have any fond memories of that?
Yeah. I'm glad you referred to that. It was a peculiar case. As you are aware, Section 29 of the Income Tax Act says that the assessment of business or professional income will be made in accordance with the provisions of sections 30 to 43. In that case, the assessee felt that he did not want to claim depreciation. For various reasons, maybe. Maybe he was selling the asset, and if he had claimed depreciation and then sold it for a higher price, he would have had to pay the difference. Whatever it is, he didn't want to claim depreciation. The officer said, 29 says I must make the assessment according to 30 to 43. Between 30 to 43 is 32. And 32 says assessee is entitled to depreciation of so much. So I'm giving you depreciation. In Mahindra Mills, the assessee objected to that. It doesn't mean you must automatically give. It is if the assessee claims it. And the court upheld their stand.
And I want to share with the audience what the Supreme Court said when Mr. Dastur appeared as an amicus. And they state, we record our appreciation of the assistance rendered by Soli Dastur, who appeared as amicus curiae on our request. He made a splendid presentation of law on the subject. Now coming back to another institution that's very close to your heart, Soli, the Income Tax Appellate Tribunal. Recently, there's been a major change in the appointment procedure. Earlier on, people used to be appointed and then you would retire at the age of 62. Now it's a contractual appointment for only 4 years, subject to renewal after that. How do you think this will affect the institution?
You're quite right. The Income Tax Appellate Tribunal, as existing previously, has received unanimous compliments. Everybody has felt that all tribunals should function as the Income Tax Tribunal because it acted fairly and decided matters without bias towards the revenue or the assessee. Its constitution is also unique, as you know. There is an accountant member and there is a judicial member, with the result that both accounting problems and judicial issues are in the minds of the tribunal. Now, they've amended the position and they have provided that a member will be appointed for 4 years and not till the prescribed retirement age. Now, I think anybody would say that to appoint a person to decide judicial matters for a period is suicidal. Why? Because he will think, after 4 years, if I decide all against the revenue, they may not renew my appointment. So therefore, his decisions and judgments will be colored. We are human beings, will be colored. Not deliberately, but is bound to be colored by the fact that since his reappointment is to take place after 4 years, he should decide cases so as to please the revenue. Now, this is particularly so where one of the parties before him will be the authority who will decide whether appointment should be continued. Every matter he decides, government is a party, either as an appellant or as a respondent. And government will have to decide after 4 years whether to renew his appointment. So therefore, it is bound to lead to miscarriage of justice. No dishonest intention in the part of the member, but bound to be. We are human beings. If you feel you will do something in this way, you will benefit. You're bound to do that. And therefore, this rule of 4 years makes no sense. Particularly bearing in mind, I would think that if a person becomes a member, for the first 2 years, he will really be learning what to do, how to behave. And therefore, his practice may really be only for the remaining 2 years.
No, I thank you. And I think I really hope that the powers that be listen to your sage comments, because ultimately this is an institution that has stood the test of time and hopefully will continue to do so in future.
And one more thing, please consider. For there to be a tribunal which inspires confidence, it should contain persons who were previously in government service, maybe, and also independent professionals. If you just have persons who are in government service, who were previously officers or not necessarily revenue service, government service, in some administration department, but still government service. A professional is bound to not accept appointment as a tribunal member if after 4 years he may not be appointed again. And having been a tribunal member, he cannot practice before tribunal in the state where he has been. So he would not like at all to do it. Therefore, today, as it is, professionals are not anxious to become or decline because they earn much more in the profession. This will be an additional reason why professionals will not join. And therefore, your tribunal may consist purely of government officials. And that, I think, is certainly not desirable.
So the next question many youngsters would probably want to know, because tax law, as you mentioned, it involves not only understanding so many statutes, but also deep engagement with numbers, accounting principles, etc. What are the essentials, if I was to ask you, of being a successful tax lawyer?
I think more or less what I said earlier, that you must be prepared to devote time, even if it means you are sacrificing some personal pleasure. Because unless you have analyzed the situation, analyzed the case law, the facts completely, you may be on a wrong footing if the judge puts that point to you or the opposing counsel puts that point to you. So one has to look at the entire case law situation, decide what to cite, what not to cite, and more important, if what you think is against you is cited, how to meet it. You should be prepared, because if it is suddenly cited, you may not be able to give an answer. But if you have read it and you formulated an answer to it, it will make life simpler and your arguments more effective.
And I think, speaking from my memory, I think what you taught us was the thoroughness of preparation, as you say, and you have to be prepared for more than just the question that you are going to argue. You have to be prepared for the questions that can come from either the judge or the other side.
Absolutely.
And those anticipation is critical.
Absolutely. The normal good lawyer will prepare his case, put forward his point of view. The lawyer of outstanding merit will also prepare an answer to what may be put to him. Because if the matter is put, he cannot say, give me time, I will find a solution. You have to answer promptly. Further, the lawyer must create a belief in the mind of the judge that this lawyer will put the facts properly. And I don't have to go deep into the matter to decide whether this is a fact properly put. That's the impression you create. If, on the other hand, the judge feels that this is a person who's likely to mislead, then he will ask so many questions. So it is essential that one creates that impression, that reputation, that he is going to be fair in what he's arguing. He will put forward all his client's points, but he will also remember that he has to be fair in putting it forward.
Now, a new part of the evolution that we have seen in tax law is this concept of faceless assessments for many taxpayers. What do you feel about this procedure?
Faceless procedures are reputed to be on advancement of scientific knowledge. I personally, maybe I'm old-fashioned, I'm completely against faceless assessment. What does faceless assessment mean? You will not react, you will not know even who's going to make your assessment. Somebody sitting in Assam may be making your assessment, you are in Bombay. Obviously, you cannot interact with him or put forward your point. But I find that If I can meet a person, I can answer his issue probably in 5 minutes, because he may raise a factual point, say, you have claimed so much as expenditure. Last year you had claimed salary expenditure of X. This time you claimed of X plus Y. Why? I could factually tell him that yes, this is a position, I retained more people, I had more work, whatever it is. But this you can explain. In faceless assessment, this is not an option available to you. Also, I find, I don't know whether you will agree with me, that faceless means I file a return of income. The officer will make an intimation in which he may change the figures. I may have shown income as X, he may put income as X plus Y. I may have put expenditure as X, he may put expenditure as X minus Y. But he will not tell me why he's doing it. I have to go through the intimation, see what are the changes he has made, and then the normal rule is you apply for rectification by filing an application under Section 154. I find at that stage also, you only file an application, you don't put forward any particular arguments. Again, subject to correction. Officer will dispose of your application 9 times out of 10 by repeating what he has done in the intimation. And what is surprising, I have seen cases where the order he passes under 154 will have the subheading or the inviting observation, order rectifying intimation. But there is no rectification. And therefore, particularly bearing in mind that the old procedure had received universal appreciation and recommend. I don't think anyone ever commented adversely on it. To change it drastically, there is no justification. And what has the government put forward as justification? Finance minister after finance minister has said, there is a lot of corruption because of interaction with the officer. And so we are avoiding it by putting in the faceless procedure. Now, if your employee, that is the officer, is corrupt, what the government says, you take steps against him. You don't deprive the assessee, whose assessment he is making, of an opportunity to function in a manner which he has done before and which has been approved. So there was a reason for installing faceless makes no sense. And that is why people have observed faceless is useless and pointless. And I'm inclined to agree with it.
And one of the concerns and feedback is that qua taxpayers, the government or the officer on the other side is faceless, but the officer knows who he is dealing with because he can see you even in that faceless interaction. So therefore, assuming he is inclined to sort of, how should we say, negative ways or in immoral ways, that may still not be prevented. So I think they'll have to really relook whether this has reduced, if at all, or has had any significant effect on the main reason, which is to reduce corruption.
You are absolutely right. If you are inclined to be corrupt, you will always find a way in which to make money illegally. If you are honest, you will not. Because I'm told today, there are quite a few people who know who wants to corrupt the officer and who are the corrupt officers, and who specialize in putting the two together. If this is so, I have not any experience in the matter. If it is so, you will agree it is completely condemnable. because you are helping the corrupt and putting the honest at a disadvantage.
Coming back now again to some reflections on your career. When you were a student in Government Law College, you wrote an article which was titled, "Is Life Worth Living?" A few years back, you wrote another article, "Is Life Still Worth Living?" What do you think now?
Actually, whether life is worth living depends to some extent of the experience you've had. And generally, I don't think a person who has found life worth living will come to a contrary conclusion later, unless something very drastic has happened. In fact, as time goes by, events take place which make you feel that no, life is worth living. For example, today I've had a chance to react with you and to put forward my point of view, which I did not have previously. Does it not make life worth living insofar as I'm concerned?
For both of us. You've had a very long and illustrious career. Looking back, what have been the most rewarding aspects of your journey?
I recollect there were about 40 juniors and interns who have passed through my chamber and are today occupy leading position in professional life. And I feel that is extremely rewarding insofar as I am concerned. Somebody may say, you argued XYZ case, which was difficult, and you succeeded. Is that not rewarding? That is personally rewarding, not professionally rewarding. When you find someone who has graduated from your chamber, is doing extremely well, that is professionally rewarding because you are putting something into the profession which has given you so much. A personal victory, you are not putting something into the profession. You are just adding to your own personal glory.
Well, as a recipient of that, I am totally and deeply grateful for all the investments that you have done in this professional part. And it's not only the gratitude of so many of us in your chambers, but this is recognized across India. In fact, I can just pick up a comment made by Chief Justice Qureshi, who sat on the tax bench for nearly 2 years in the Bombay High Court. And when he was promoted as Chief Justice and was leaving the High Court, he said that some of the finest counsels are from the office of Mr. Soli Dastur. Mr. Soli Dastur has had about 20 to 21 juniors. And today we have at least 5 or 6 quality all India arguing counsels from just one chamber. We need more Soli Dasturs in this place.
I hope no one has filed an appeal against that judgment.
How do you see your legacy? And I can also say on this point, one of the most difficult places to get into, apart from your chambers, was into one of your budget speeches, which kept being moved from larger and larger venues because last year's venue was insufficient. And I have fond recollections that if we were to arrive a little late, we would not be allowed into the venue because it is already full. And I believe at one time, even Jal had that experience where he had to say, I am the speaker's brother to be able to get inside. And the person at the gate says, no, but everyone will say he's his brother. How can we allow? So how do you see your legacy?
I must compliment you on the research which you have done. I do hope the uncomplimentary aspects which you may have come across, you will not put forth. Yes, the budget speeches did give great satisfaction. If I recollect correctly, Initially, the budget speeches were in, say, the Jai Hind College Hall. Later, they were in bigger places. And again, if I recollect correctly, must have given about 30 speeches on finance bills. And the interesting part about lecture on finance bills is that it contains some new provisions and not something which is already covered by case law. And one has to analyze that. What will be the impact of that on the action which you take, and what will be the impact on that on cases which are decided? And therefore, that budget speech, which really gave one very little time, because the earlier one commented on it, the more useful it was to people, did give a lot of satisfaction.
Thank you so much, Soli, for this wonderful time. And I can only say that you have approached this podcast with the same effort that you would do a case, and the amount of effort that you have put into this is deeply appreciated by both the Bombay Bar, myself, and everyone here. Thank you.
Thank you. Thank you very much.